Hi there, you're with BQ Prime, and this is the fine print. Parathas will attract an 18% tax rate and cannot enjoy the same privilege of 5% rate as on roti, chapati, or khakra. No GST on papad, but fryers face an 18% rate. Pizza toppings, pretending to be cheese toppings, must go in the 18% rate. Memes, disapproving remarks, and some laughs. Disputes around GST rates on food products gave us all. On a more serious note, the struggle to get transition credit was quite real, with India Inc. rushing to High Court with writs for relief. In the last 5 years, the Supreme Court too answered some important questions for supply of ocean freight services, refund of unutilized tax credit of input services, secondment of employees, etc. Of course, the Apex Court's recent observations on the weight GST Council's decisions carry led to a lot of worried editorials. And then the news around GST officers using their search, seizure, and arrest powers rather indiscriminately made a lot of businesses nervous. This short introduction doesn't even begin to cover the GST litigation we've seen in the last 5 years. In spite of the dedicated forum, that is the GST Tribunal, still a long way from becoming functional. On this third part of our special series on GST's 5-year anniversary, two of the most credible and experienced legal voices join me today to talk about their experiences as they went from court to court. Senior Advocate Arvind Datar arguing for businesses and Additional Solicitor General N. Venkataraman making the case for the government and its officers. Gentlemen, many thanks for joining us here on the fine print.
Thank you.
Mr. Venkataraman, let me start with you today. We very rarely get to hear the government's point of view or the revenue department's point of view, and you have a massive insight into that. How has GST litigation kept your life busy in the last 5 years?
3 years as assessee counsel and 2 years as revenue counsel. So I had the experience of both. Important litigations are slowly getting decided either at the Supreme Court or at the High Court level. Very important litigations. So happy to be part of it. And as a revenue counsel, enjoyed 2 years of wonderful exposure, meeting my own colleagues and friends, a battery of them on the other side on many matters. Learned a lot, and we also try to contribute our best to the government side. It was a wonderful, worthy learning experience.
Mr. Datar, slight complaint from the ASG there that he's faced with a battery of lawyers always on other side. Can you give us a little flavor about your observations? We'll come to the specifics on how courts have looked at this, massive reform and tried to make sense of, some of the issues that it has had to deal with.
Yes, as Mr. Venkataraman pointed out, very important issues have been decided by the Supreme Court. I think some of them are also in the pipeline, which will ultimately get decided. The only thing is, I thought that if they had structured the GST better, there would have been lesser amount of scope for litigation. Unfortunately, what I find is sometimes the positions taken are so difficult for the assessees that litigation becomes inevitable. Like you mentioned about papads and different rates of tax is one point. We don't have proper alternative mechanisms. We have to rush to the High Court. There's so many issues which are pending, but I think many issues can be sorted out if there is a more reasonable attitude by the department. Many cases need not even start. We have got cases of multiple demands on the same point again and again, forcing the parties to go to court and things like that. So I would say that on legal issues, yes, there are some issues on interpretation because of multiple classification lists. The law, there are definitely some advantages. It would be wrong to say that GST is just an endless tale of woe and complete wrong. There are many, many plus points also. But I think that a lot of pain points can be avoided at the threshold if the government takes a more reasonable attitude, takes a more purposive interpretation, rather than focus on maximizing revenue at any cost.
That's a constant feedback, Mr. Venkataraman, we get, and this conversation is by no means putting you on the spot. But what we've tried to get from you in this conversation is some of what you hear from the GST officers as you go to defend their positions in court.
See, there has to be definitely more than one view. Let me provide you the view from the government. It's not that every pursuit of investigation is vexatious or frivolous. It's too tall a statement to make. There can be excesses in some cases, which as a professional I may not be able to deny it. But to therefore benchmark every case as an irrelevant pursuit is simply an unsustainable statement. We have, if you see the bandwidth of investigation that is currently happening in India on the GST matters, somebody shows a product of export not even worth, say, 50 rupees. You fake it 10 times and give a value of 15,000 rupees and go and claim a rebate on that. To say that we should not be activating our investigation efforts there, it's all excess and all. And that's somebody to take a call. There are, my friend was taking about, let's take Poped and take France. Both are not the same. The consumption pattern is extremely different. One is very marginal and very, very specific to a particular category. Rest is, the other one is so easily affordable as a item. So having a different rate of tax, how is it wrong? It's a policy issue.
Yeah.
And
I
three,
think, yes, please go on.
one more I'll just, on intricate matters of classification and valuation. We are right now running out a litigation, investigating it very deeply. Matter is getting fought in a high court. Just with one assessee, it runs to several thousand crores, several thousands of crores, with just one assessee. And if the pattern appears to be right, then if you replicate it with what is happening across, it will be stupendous. So these are all issues on valuation and classification, which are very sensitive. Therefore, these are all, you find it only after investigation. As part of investigation, and to find fault that you should not do it, somebody refuses to divulge the passcodes of an electronic gadget for 3.5 months. He refuses. What do you do with such people? So we also have such transactions happening in the country.
Yes, I fully agree with Venkataraman. If a person is being recalcitrant, there's no excuse for not giving the information to the department. It's a citizen's right to cooperate with the authorities for investigation. I don't say, and Venkataraman will agree when he was on our side, we have cases where there are people who are outright violators of the law. Well before he started practice law, I know cases where there used to be a lot of export benefits given, and I know people who have exported containers of chalk powder, claimed it to be some high value items, and then got all the export benefits. These are cases happening from early time also. I know people who would say that they got some units of some remote part of Northeast, import goods and sell them in the black market. Nobody says that this investigation should not go on. What my point is when I mentioned this question is, let's say on classification. Now, I know of 3 cases where on certain products we have succeeded up to the Supreme Court. We have come back. Now, again, they are raking up the same issue in the GST, some circulars are issued. So this could have been wholly avoided. That's my point. I also agree with Venkataraman that fry and papad, or let's say, for example, a plain biscuit which a poor man uses, or a high-priced chocolate biscuit somebody is using. But I'm saying that if you're aspiring to be a 5 trillion economy, the basic mantra of GST is a single tax, or at the most a dual tax. We should not worry about the one papad or one thing. Suppose you have a 12% tax for all food products. Forget low. It's better, because what will happen is if the company makes more profit, he's going to pay income tax. I've got 2 quarrels as far as this policy issue is concerned. First of all, it is historically established that the higher the tax, the greater the evasion. There's more chance for arbitrage. If you say a shirt below 1,000 rupees will be nil and a shirt above 1,000 rupees 18%, it is a sitting duck for arbitrage. Why can't we simply say all garments are 15%? There's no harm in that. So if you're aiming to be like Singapore, like a Western economy, then you must have flat GSTs. This entire mindset that an expensive car should be taxed at 28%, this thing should be taxed at 5%, is not on. Everything has to be, I don't see why we can't have a maximum rate of 15% or 18% on all the products. And I know, for example, the real estate industry, for example, this joint development agreement is creating havoc. There's so many pain points which are hindering growth. And the other thing which I've got, both of us are tax lawyers, which I've seen from close quarters. We focus on revenue maximization, not realizing that what's the collateral damage you make. You're making your own economy high cost. You're making people run away from India. These are things I'm seeing on a day-to-day basis.
Yeah, I don't think, Mr. Venkataraman, anybody can dispute with the genuine cases of investigation. What sort of I think comes to the fore is also a lot of overzealousness that we see on the part of jurisdictional officers. To what extent are you, as their counsel, are able to say that, hey, look, this is not a great case to take to court? Or is it that, most cases end up being to court?
We can certainly aid you with some good answers there. At least the present set of law officers in the Supreme Court, we are committed to being very fair and transparent, and courts actually respect us for that. So if there is no case, we have never shied away in conceding that there's no case. And now at least several of these which could have been filed in a very routine manner, we have expressed our opinion that these are all matters not worth pursuing at the appellate stage. So we had last 2 years, our track record has been quite, I can say this as a matter of pride, that and government respects our views. It's not as though that there's a fear. No. You give your reasons why it should be done or why it should not be done, and it's respected. So we have that confidence. They have the confidence with us, and we are certainly trying to aid the court. Courts are certainly very clear that we don't fight around things. 2, this is one development. The second development, which will be of interest to the trade, is abuse by the executive arm or the officers or the administration. Courts are no longer viewing tax matters as they had viewed 10 years or 15 years ago. Okay. Courts are quite tough and quite policy friendly, quite assessee friendly in most of the matters. Any violent abuse will be condemned. It will happen if something's up. So this course correction is happening and will happen and will still at some point of time. And all of us are very fair and transparent to that extent. You should you can check it up with Mr. Datar, whether we are fighting wrong cases, not at all. But where there is a case for the government, we just don't yield it. Come what. That's something which we don't compromise.
Mr. Venkataraman, you mentioned that there are, of course, positions that you have taken. Can you give us within the, let's say, conversations on whether it's utilization of credit, whether it is transition credit or classification? Could you give us a favor of?
I'll give you an answer for all this. I'm happy. See, transitional credit is something which we could have really avoided. This is my personal view, and I have convinced the government, the executive arm of it, and 5 years of litigation. Hopefully, we have taken some policy views, and the government is extremely cooperative with us in that. Hopefully, when the matter comes up after reopening, we would be giving a solution, a one-time solution, which will solve 5 years. Okay? And government is with us in this, and executive arm is working with us. They're very cooperative. So it is possible. So when you give the right advice, the system takes it. So this is on Tran 1 and Tran 10. On 2, we are now very responsible when it comes to Supreme Court's guidelines issued to us. In VKC footsteps, we won the case. We succeeded on law. But the court guided that the formula should be better. Now, 47th GST Council meeting, we have amended the formula. We have given
on the input services where there was inverted tax structure.
The formula should be more fair and user-friendly.
Yeah.
And we took our time to work on it. But we have finally, on 47th GST Council meeting, we have implemented the guidelines issued by the Supreme Court. So please be aware that guidelines, thresholds, whenever indicated, we are working on them. Last one aspect, which Datar raised it, which is a very valid question, a very valid issue, which we try to give an answer. See, can we have a one rate? We will not be able to have a single rate that easily. and comparing it with Singapore or European nation, 25 European nations put together is India. And Singapore is not even half of Tamil Nadu in size. So we have our own issues.
Mr. Datar, we can of course talk about the specific litigation, areas ad nauseum, but let me come to the forums. Okay, we have the authority for advanced rulings. There is a GST tribunal that is contemplated, and in the 47th meeting, the finance minister then said, this needs more deliberation. There is a group of ministers committee that will now put together a report and submit it to the GST Council on how this GST tribunal should sort of, come about. This is, of course, in the background of the Madras High Court saying that, the council, the tribunal should have either equal or more judicial members as technical members. And now the Supreme Court has also told the government to expedite the setting up of this tribunal. In the absence of this tribunal, how have you seen, let's say, businesses, cost-wise, time-wise, efficiency-wise, suffer because they didn't have the right forum to go to?
See, this question of GST tribunal now, they say that they're going to consider it. I've been suggesting that the excise tribunal was working reasonably well. I mean, every tribunal has got pluses and minuses. We've got the working of the CSTAT now for almost 40 years. 1982, the CSTAT started. So we've got a 4-decade legacy of the working of the tribunal for indirect taxes. I've suggested that we've got a concept of a judicial member and a technical member. Let that continue for GST also. Now, one view which seems to be a hurdle is that I think Venkataraman can correct me if I'm wrong. One view that is taken is that there should be one technical member from the central government, one technical member from the state government. That is the problem. So they want one member. And the viewpoint is that somebody has to protect the revenue. See, my point is that tribunal is not there to protect anybody's revenue. According to me, if there is a technical member, whether from the central government or from the state government, suppose tomorrow there is a GST tribunal in Tamil Nadu, a technical member can very well be a commissioner who gets selected through the tribunal process, say from UP or because litigation is English. The law for central government and state government is identical. If he is going to interpret whether a papad or a fram should be 18% or 12%, it doesn't matter where the technical member comes from, where the judicial member comes from. So we can really start the thing going by asking the CSTAT to continue with the GST tribunal. So I think the faster they resolve this tribunal issue, the better, because everything is stuck at the appellate level. As far as authority for advanced ruling is concerned, well, I must, I don't know how to put it, but the situation is not very happy. People go to the authority for advanced ruling knowing, confident that they're going to lose the case. And then it's just a track record to get to the High Court as fast as possible. You see, the whole difficulty is when you have, I think Venkataraman has done far more advanced ruling cases in income tax in the early days. I see his name in the reports. The advantage of having an advanced ruling is that you get some certainty on your tax position. You're going to start a new business. It's a new question. See, advanced ruling is not on a settled question. It's on some new problem. You go for an advanced ruling and you get the issue settled. Now, who will decide the tax liability? It should be an independent person by definition. It can be a tribunal consisting of 2 people. But if the same commissioner is going to sit in the morning as a commissioner and sit in the afternoon as a ruling, it's very difficult to expect him to give a view against his own department. I mean, mentally, physically, it's not possible. So unless you have this AER as an independent body, it's not really going to work. It is going to be, I don't think it's, I mean, I'll put it bluntly, most of the SSCs are not very happy with the existing setup. Now we can say, no, so many cases are good, but we've done about 1 year back, we found that 81.5%, 82% of the cases were against the SSCs.
Mr. Venkataraman, first coming here on the, the functioning of AERs, because, I'm going to quote from a Deloitte survey where at least 50% of, industry said or expressed their dissatisfaction over how the AERs have been functioning. And as Mr. Datar pointed out, it's practically becoming a route to get to the High Court.
As a lawyer, this is what I have said about GST. See, and this is my personal view. I've always said, I think people who have authored the GST law, they took so much pain in drafting various sections that they got tired when they came to appellate remedies. Okay, so all is not so well there. And I've said so in forums, even as a law officer. 2-3 things we are trying to do. See, the problem, if, for example, in AER, or for that matter, the possible tribunal which is going to come. The personal view is, you need not have an AER in every state. You need not have a tribunal in every state. But how do you now allow a fusion in meeting the standards of cooperative federalism? See, it's a constitutional requirement. So suppose we start initially, all at this stage of, there's no commitment. It is an idea. Suppose we start with 4 or 5 tribunals in different regions. We should accommodate the aspirations of you can't function otherwise. This law has to function with consensus. You must give me a couple of minutes when you talked about the latest your concerning editorials. I want to say something very, very concerning about it after this. So we need to synergize the interest of states and the union. At least the GST is very particular about it. Our objective has been total consensus, and we have been achieving a phenomenal success in these 5 years because most of the decisions are consensual. So you can have 5 tribunals or so. And whenever a matter from a particular state comes up, you can possibly have a regional representation there as a member. There's nothing wrong. You don't have to multiply tribunals for that reason. If you multiply, then plurality of views, conflicting views, these are all inevitable. So you can have regional representation in each of the tribunal whenever matters from that specific state comes. You cannot dispense it. You won't be able to function if you say that I'll have only a central member or I'll have only a state member. These are all issues which we need to coalesce. But we can rationalize this. Same should be the case with AER also. You can't have AER in every state. It's not going to work. And a man who has 10 businesses has to move in 10 different AERs and he gets 12 different ideas. So rationalization is one important remedy which can look upon. We are trying to suggest it. But there are counter suggestions also, because accommodation, aspirations. See, it's like this. Before GST, that law had tribunals in every state. Yeah. So how do you, it takes time. It takes time.
It's an HR problem as well.
Yeah. And we, therefore, a harmonious solution, that's why a GOM is now created. A working paper is now thought of. So people will give inputs. Let people give inputs.
Sure. I just have a quick follow-up on when you mentioned, okay, have fewer GST tribunals, don't have it in every state, have fewer AER benches. Is there sort of a rethink on the constitution or who is sort of manning those AERs? Because as Mr. Datar said, it's difficult to take a different view in the morning and wear a different hat in the evening by the same person.
See, I mean, the standards of AER and income tax, when it was led by a retired judge of the Supreme Court, and that kind of judgments that got delivered it's of a different class. So we should it should be less bureaucratic and more efficient. That's what Mr. Datar is expressing. I don't think I have a different view in that.
Mr. Datar, I'll move on to an area which we get very let's say polarized views over, and that's to do with the tax administration's powers of inspection, search and seizure and arrest. Of course, for inspection, search and seizure, prior written permission of Joint Commissioner is necessary. For arrest, there is a higher threshold of the Commissioner's permission is needed. How have you seen these powers manifest, in the last 5 years? And is there truth to the allegations that they're probably not sort of used in the most prudent fashion?
Venkataraman talked about tax philosophy. According to me, giving the power of arrest to an executive officer is not proper under any civilized society. Power of arrest must be with the permission of the magistrate and so on and so forth. The feedback that I get from my clients is that this power has been very misused to a large extent. And I can give examples where I can't say it on TV, but there are very many cases where just come and say that unless you pay X number of money, you'll be arrested. And so on. It's happened again and again. There are people who have been just simply arrested and then they are in jail for 90 days and without any charge sheet being filed. After that, there is no trial. When I check with some people, they say, no, the criminal system takes so long that this man will never get punished. Let him at least be in jail for some time as some kind of terror. Now, see, having practiced tax for 4 decades, this thing never worked. You take income tax, for example, 97% of the money is collected by advance tax and TDS. So the entire litigation, fight, evasion, search is for this just 3%. I mean, it's grossly disproportionate. And what I've seen, unfortunately, it doesn't really work. And that's what really puts off many people is this system, which is, apart from revenue access, oriented towards catching a few people who evade tax. And for that purpose, you amend the law, which hurts everybody. I mean, this has been a consistent refrain. One group misuses charitable trust, therefore you bring in section 11.5 and really harm good, genuine charitable trust also. So this is a common problem. So to answer your question, at the ground level, there are multiple problems. One, there is no accountability for person. And contrary to what Venkataraman said, I don't think many high courts are SSC friendly. I'm sorry to say that. Depends on individual people. I mean, we are having a frank discussion. There is nothing wrong. We don't find that at all. And there are cases. Of course, what is going to happen is in any system, there will be abuse. There will be some genuine cases where they really put a person in jail who deserves to be in jail. There are also cases. But I know of cases where, for example, if there's some expansion going on or if some IPO is going to go on, suddenly people have landed and they've said that unless you pay bill. Second point, which I want to ask Mr. Venkataraman also addresses, very often media reports are given saying that Mr. Datar was found with 100 crores, example. And there is no provision for getting Mr. Datar's feedback. And I know of cases of mine where I've had it myself, where what has been put in the press is factually not correct at all. I mean, you already condemned a man by a media report. And that has completely upset his banking, his everything, and so on and so forth. So, two things I will mention. One is the power has been misused. Maybe I do not know the percentage, but it has been misused. According to me, as a matter of law, there should not be a power of arrest given to an officer. Thirdly, this kind of media reports which are put into the media straight away without any kind of contradiction from the other side is also very, very harmful to the industry. So there is definitely a fear psychosis. So Venkataraman may say yes. See, you don't have Venkataramans at the lower level. We have Venkataraman only in the Supreme Court. There are many officers at the ground level who are not doing that. But you ask across the board, if you take a sample survey, there is definitely a fear in it.
Yeah. Mr. Venkataraman, I'll come to you with 2 or 3 points. One is the point that Mr. Datar mentioned on, is there a way to build accountability in the law? I know in faceless assessment cases, at least the Bombay High Court has pulled up, officers and said that, look, if you keep coming with these reasons or not giving show cause notice or following due process, we will haul up individual officers and even go to the revenue department, revenue ministry. The second point, that's sort of, of concern is that closer to, monthly targets, there is harassment. There have been harassment in Karnataka High Court. I know of a couple of cases where directors were kept, in the GST office till up to 2 a.m. and 4 a.m. And, those directors had to pay up to physically get out of those premises. Is there sort of, not enough out there for the government to take notice, and then maybe for those 5, 10, 15 odd cases, build some accountability in the system?
You have answered one question my way. I'm happy about it. When Mr. Datar says courts are not SSC friendly, I mean, I have to disagree.
No, I said all courts are not SSC. I'm saying
no, that's right. All is a good adjective. But there is a transition happening. People are getting hauled up for wrongdoings in the system using bureaucratic power. So this was not happening 20 years back. In fact, there are 2 laws where the presumption is actually in favor of the accused, criminal law, and in favor of the assessee in claims of tax law. But courts were shielding it those times. It is not so now. That's the point I'm trying to say. So there is this change is happening. And it's for the good. See, let's also realize it. If a few people get hauled up for abuse, then there will be an internal course correction and internal mechanism will get sounded better. So this is see, only judiciary has to do this course correction. It will take some time, but it has all I'm that saying is it has started to happen. So this will have an impact on officers and their promotions, their scales, everything. One. Now, two, I do agree. The case which you cited about Karnataka High Court, I can at least say this personally. I declined the brief when I had to appear at an appellate stage, saying that I don't know why this is happening. And both the courts, the single judge and the appellate judge, had upheld it. I had quashed it, had interfered it. Therefore, the answer lies there. If you have attempted to abuse, then courts have indeed interfered in that matter, which you're citing, where somebody was held till 2 a.m. or 5 a.m. So courts have interfered. Three, I have always been asking this with the trade. Whether it is IBC law or GST, any law, give us, you don't have to disclose identities. Give us empirical data against every 10 cases of arrest. How many are injured? Give us empirical data. See, we are making statements in public domain. And we carry a responsibility when we make a statement, whichever way you argue. So show us out of 10, is it 7? Is it 9? Is it 9.5? Or is it 2? I can assure you, when it comes to tax demand, the abuse could be on a slightly higher order. It's possible. Tendencies are there. But when to arrest, it's not that 9 out of 10 cases are abused. It's something which is not correct, because we are handling matters at the ground level. So it could be less than 20%, but still you are interfering with the liberty of an individual. 20% is not tolerable. I agree. Now, can you believe, after a lot of discussions, I cannot make it public. We are now trying to draft a clear, it will happen, a clear SOP for investigation and a clear SOP for arrest. We are now working on this, very, very, very focused. I can't give you the details at the moment, but we are working on it. So you will get a standard operating procedure both for investigation and also for arrest. So this is likely to resolve a lot of inconsistencies. It's hard belief. If somebody dares to abuse it, then he or she will face it in the court. So this is one step we have taken on these two matters. And it will take little time, but we are working on that. We are working on that.
Personally, I'd like to say something at this stage with your permission. See, two things are there. One is we have got the power of arrest. The unfortunate thing in our criminal justice system is no magistrate is going to give you bail. Today, what has happened is, whether you like it or not, jail is the rule, bail is the exception. I have not in my life seen a single case where in GST or service tax, a person has gone to bail, whose magistrate has given him bail. Whether you talk of a case on drug or something like that, it takes GST. Everybody is remanded to custody for 15 days. So once an arrest is made, there is no chance of your getting bail on the first day. No chance at all. Number one. I was suggesting to Mr. Venkataraman, if they got a standard operating procedure, you want to have an FIR against, say, my company. Suppose I'm found to have, there's a prima facie feeling that I'm evading tax. Why arrest me? You can file a charge sheet, you can file an FIR and say that, all right, you please surrender your passport. Don't leave Chennai or Delhi without the permission of the commissioner. Something, why put the man in jail for 15 days? You see, and going to jail, your reputation is tarnished forever. You can't get a bank loan. I know cases, I'm sorry to say, where the person was put in jail. It was published all over the papers. Subsequently, the whole thing was dropped, but his daughter could not get married for 9 months. These are all practical ground reality problems. Why arrest a man? I don't understand. And Mr. Venkataraman said, please give us empirical data. I have told people, please give the data. I will give it to the people at Venkataraman. Nobody wants to. There's such a fear psychosis. They say, look, if I tell you, because I must tell where the arrest took place. If the government is going to take, they'll say, give us concrete example. Where did the arrest take place? What was the kind of thing? The moment that data goes, they know who is the person involved. And nobody wants to give it. I've asked people, please give, because Not only Venkataraman, somebody else told me, just give us concrete cases, we'll do something about it. At least we'll find out. They are simply saying, sir, we don't want any kind of thing at all. We are afraid because the moment we do it, we'll know it. So this has to be addressed by Mr. Venkataraman and the government at the.
Mr. Venkataraman, to all the points that Mr. Datar made, I'd like your sort of view on that. And I'll quickly make one more point, that how difficult it is to give the power of arrest to, let's say, a commissioner or a joint commissioner and take that away from individual officers. How sort of realistic is that for the industry to expect?
For us, with a higher officer, that you yourself said. Now, for decades, all tax enactments, see, when executive has to collect it, and executive files a huge violation and breach. Now, to say that such an executive should not exercise the power, it's a dilemma. See, we are the churning process. I repeat once again, there can be excesses and abuses. I'm not saying no, and courts have interfered. But the kind of arrest we have attempted to make, and people are now on bail at some point of time, with an evasion of 240 crores in fake invoices, with hundreds and hundreds of false Aadhaar cards for 400 and odd units. The existence is hardly for 12 days to 3 weeks. You have a PAN account, you have a bank account, you get something deposited, recycle, and you will be some cycle rickshaw fellow with no address. These are also, we have to see the whole spectrum. So this is also happening, as that is also happening. So in pick and choose, if there is some wrongdoing, I'm not justifying it. Because arrest is interference with personal liberty. It's an extreme action, and constitutional protection under 21 is rather extraordinary, no doubt about it. But there are cases where you need to necessarily resort to, because with these type of fellows who don't have a PAN registration and a GS registration, not even for 2 weeks, what do you do with these guys here? You have to give an answer for such evaders also. So these are the extremes we have. So you need to understand. That is why we say, I understand the reservation to give, but how do we go? See, we are now drafting SOPs for both. We will certainly sensitize if we have some data. Don't disclose anything. Give us raw examples. We will see whether something can be done. If a remedy is possible, we'll work for it.
Mr. Datar, I'll give you the final word. Could you help me with 2 or 3 key areas that you think the government should focus on as it sort of, looks at how the absence of a GST tribunal have impacted businesses, how the AERs have functioned, how the overzealousness of the individual sort of revenue officers has, been problematic for businesses. Can you list for, the policy makers out there, the 2 or 3 key agendas for the next 2 or 4 years for the government?
Yeah, I'll be quick. First, let me start with the tribunal. I think it can brook no delay. We already spent 5 years. And Venkataraman is right. I mean, each state wants to have their contribution also. One simple way is to have a tribunal. Suppose you have, let's say, 10 benches in the country, and you're going to have, let's say, 10 judicial members and 10 technical members. Then let the technical members be selected from different states and center, or you can have the technical members from the states, some from the center. Because what's happening is GST is now a fusion of excise, service tax, and VAT. So each body wants to have their own say in the matter also. But at the same time, you've got constitutional bench judgments of the Supreme Court which don't permit technical members to be the majority. That's the law. There's nothing we can do about it. So we have to sort out that particular issue. So what I thought was, suppose, for example, I'm just suggesting, have a tribunal where there are, let's say, out of 10 technical members, let there be 3 from the center and majority from the state. So the state's thing also is balanced, or have equal, whatever you want. And for each tribunal, don't have for a Madras case a Madras tribunal member. That's not correct. You have one, then that the question of independence starts being question mark. Once I'm a tribunal, I'm appearing before a person who are equivalent to judges, who will decide my case fairly, irrespective of where they come from. I don't want a person from Madras to come. Then again, why should a Madras person? Because there is no separate law for Madras or Tamil Nadu. There's no separate Tamil Nadu GST as different from Maharashtra GST. The same section 54, the same rule 89 is going to be interpreted by the concerned people. So have a tribunal, have technical members, and then, as Venkataraman says, start on an experimental basis. At least start 10 benches functioning, see how they work. Don't have a solution immediately. See how the benches work. It'll be a learning process. Then you can have it for 2-3 years, make a correction, because now GST is going to be there for 30-40 years. So it's a long haul now. So you start that, number one. That's as far as tribunal is concerned. As far as AR is concerned, I agree with Venkataraman's suggestion. There is no point having 28 AIRs and then 28 things. You have 10 AIRs. But if you're having 10 AIRs, make sure that they're independent people. Get retired from the department. I don't bother. Get a person who's a retired officer who has served, a retired judicial member. Have a person who don't have any umbilical ties to the department where they serve. That's as far as AR is concerned. And secondly, an AR which is not going to give a proper ruling is really an oxymoron. There is no point. It becomes an authority for adverse ruling rather than advanced ruling. Number two. As far as the third point of arrest is concerned, I agree with Venkataraman. If you've got a case where a man has got 400 fake Aadhaar cards, etc., yes, then that's the that may call for an arrest. But I know of several cases where the threat of arrest is used as a leverage to take money in advance, take tax in advance, and then not issue show cause notice for long. So there is definitely a point when they draft the standard operating procedure. Arrest should be the rarest exception. You tell a person, don't leave the city, report to the GST person every day, report once a week and so on, but don't put him in jail because that's an irreversible process. His reputation is never going to come back. Now look at what happened in 2G. You put people for 18 months in jail, ultimately they're acquitted. Look at I won't mention any other person you said, oh, he had drugs, etc. Ultimately, what happened? You drop the case, nothing happened. There are so many examples I can give where you put a man in jail, he suffered 3 months, 4 months in jail, and ultimately the charge has not proved to be correct. So I'm just saying that, and what will happen is then there'll be no fear psychosis, there'll be no element. Person will say, all right, I'll face the trial. Now what happens is he doesn't want to do it, and you do not know the kind of fear level at the ground. It's really, really something, a matter of great concern. And Venkataraman says, don't give us data. I talk to him how to do it. But the point is, the moment I let you know some details, the cat will be out of the bag. How to solve that is a big problem. But it is a case of serious concern. Of all the problems, we'll say, this kind of ground level threat of arrest is the very, very serious problem which is facing the industry.
All right, Mr. Datar, Mr. Venkataraman, many thanks for giving us, your views on how litigation has panned out in the goods and services tax regime, and hopefully, some of the, standard operating procedures, how arrest powers and search and seizure have to be applied will solve some of the business concerns, that we have heard in the last 5 years. Thank you, gentlemen, for joining us here on the Fine Print, and thank you so much for watching.
Thanks so much.
Thank you. It's always a pleasure to be with Venkataraman on the panel. Thank you so much.
I wish we could get more of him, sir.
Thank you.